This meeting is being recorded.
All right, so this is a new meeting. This is, I wanted to share about you. This is from Justice Jeffrey Palmer, right? So he was talking. Now, this is why our case is quite important, because they wrote about this in, this was written by Karen Grau, but it comes off of Justice Palmer, Jeffrey Palmer, not his son. We have his son, Justice Palmer, but this one is from Jeffrey Palmer, and he says that this is taken from a case that occurred, the last time that a case like ours happened was in 1610, and it's part of the case said, it appears in our books that in many cases the common law will control acts of parliament and sometimes adjudge them to be utterly void. For when an act of parliament is against the common right or reason, or repugnant or impossible to be performed, the common law will control it and adjudge such acts to be void. So that is like a lot of these things, acts of parliament are not making sense. And so they would be, now the Chief Justice Coke asserted in 1610 and Justice Cook hinted at in 1984, the question of whether the courts could ever use their power, it said. They're saying they're not sure if the courts could use their power to overrule Parliament or not. And they said the last time this occurred was in 1610, and I'm going to read you about that case so you know what it is. Now, Chief Justice Coke's assertion was not confined to Dr. Bonham's case. He reiterated his views as soon after in the Rolls-Mason, stating that if there is a repugnancy in a statute, the common law will disallow it and reject it. And in the case of proclamations, he said that an act of parliament was made, if the act of parliament was made, that all Irish people should depart the realm upon the pain of death, which was absolutely in terrorum and was utterly against the law. In that case, the courts would have the power using the 1688 common law to override Parliament. And this battle was never ever resolved on whether the courts had the right to override Parliament if Parliament was ruling in tyranny. So I wanted to go a little bit to tell you about this case here of Dr. Bonham, so that you'll understand what I'm talking about, what this case is truly about. And so the case that it's truly about is that Dr. Bonham, he was a physician, all right? And what had happened was, hang on. So we don't want to go into American law. The College of Physicians was an elite organization, and it was created by a royal charter. So it was created by the king in 1518. And it was founded by 6 English academic doctors who were trained in English universities. It admitted that only British men who had trained at a university and had passed a 3-part Latin exam in medical theory and only 24 fellows would be allowed. And that if an entrant came at a time when all 24 fellowships were full, he would instead become a candidate. And so when one of the fellowship became vacant, the candidate, the highest ranking candidate, hello sweetie, would take the case. I'll wait for Sharon for a minute because I know Sharon wants to help her little girl. Do you want to help your little girl? I'll keep going. All right, keep going. Okay, so there was an act of parliament that confirmed the Royal Charter, which gave the college the ability to act as a court on their own and to judge other practitioners and to punish those who were acting badly or practicing without a license. This is where they realized that the courts were inadequate to judge based on medical issues because they didn't know about the medicine and all of that. So the king made a proclamation that they would, only in these laws, they would give them to the medical council, and the medical council, the fellows, the 24 fellows, would be like judges over the medical profession, rather than when medical people did something wrong, they went to the court and the court didn't know what they were talking about. So this was done by a royal proclamation. The original royal proclamation from the king was to give the people's governance over to the power of parliament. And then this was another proclamation of the king where he gave the rule over the medical people into the hands of the medical profession because they were the ones that could deal with it. So for these cases, the king would not intervene, all right? So they were given two things. One was that they could judge over the practitioners. They could punish them if they were acting badly, or they could punish them in 2 points. One point was if they were behaving badly and had done bad things to hurt someone. And the other point was for practicing medicine without a license. So those 2 points are important. You need to remember those. The second act, the College of Physicians in 1553 amended the charter by themselves, and they gave the college the right to imprison people indefinitely, those that they judged, which was quite a lot more than what the king's power that he had given to them. You see, this is what is happening with the New Zealand Parliament. They're taking quite a lot more powers than what's actually been given to them. And that is what they did. So it flew in the face, it flew in the face of the common law assumption that to practice medicine, one needed only the consent of the patient. So under the common law, so the power that was given to them was only if they were acting badly. Well, that would have come under the common law because they would have injured people when they acted badly, and that would have been against the common law. So that's why they could judge on that. The second one was practicing without a license, but the one that gave them the right to imprison people indefinitely, that went against the common law because they said if the people give their consent to be treated by that doctor, then it's up to the person to do that because it's within their power. But what the doctor is not allowed to do is to hurt them. So that means if you go to just the massage therapist and you as a person give your consent for them to massage you and you don't want to accept medical treatment for your cancer, you would rather go and get your massage, that is your right. But their duty as well is not to hurt you. And when they know that their treatment is not enough to help you, it's for them, they have to encourage you to go to the proper doctor to get the medicine because that's behaving badly, right? So there's all this shit going on with them, all the girls there, all this stuff going on with them. And so that was the case that occurred. Now, Thomas Bonham, after he received, he earned a bachelor's degree, and he received a master's degree and a medical doctorate degree. And he was later granted by the University of Oxford. He completed his studies, moved to London, and he started practicing medicine. But obviously he had not passed some of the proper medical. I mean, just because you've got a bachelor's doesn't mean it was a Bachelor of Medicine. He could have had a bachelor's in business or in massage, for all we know. Yeah. Yes, because all the higher up medical stuff is done in Latin. And the real doctors know the Latin, the proper medical practitioners. And the lower ones don't know that. So
Right, the script in Latin, didn't they, in the old days?
Yeah, everything had to be done in Latin, and there was, yeah, we won't go into that, but yes, that's right. So apparently, so he campaigned to be allowed to authorize medical practitioners in the same as the College of Physicians. I don't know. He failed in his petition. He petitioned, so he was rejected by the college. And he was told that he had to go back to further study if he wanted to practice in medicine. And he returned in April of 1606, and he again was told that he could not join. And he was fined $5 and threatened with imprisonment for continuing to practice. But Bonham still kept working as a doctor, even though they told him not to. And then on October, it was announced that he was to be arrested and fined £10. After that, he appeared before the college with a lawyer, and he announced that he would continue to practice without seeking the college's permission, which he claimed that they had no power over graduates of the Oxford University. So he didn't go to medical school. He went to a standard university. And he was then imprisoned and for contempt, but his lawyer had a writ of habeas corpus issued by the Court of Common Pleas, which freed him. So the habeas corpus is the trial by jury, and he was sent to prison for an indefinite period of time with no trial by jury. And so that is where the common law habeas corpus came in, and he was released from prison because he didn't have a jury. So he won on that point. Then Bonham's successful writ started to worry the college, and the college appealed to the Crown. So they appealed to the Privy Council, who met with the judges, and the committee were Ellesmere Popham, Thomas Fleming, 2 judges from the Court of Common Pleas, 2 from the King's Court, the Court of the King's Bench came. So the King's Court came and the Parliamentary Court came. Everybody got involved with this case. And I'm suspecting if we are clever enough, everyone will get involved with this case. But I don't think I have the skill, to be honest. It's a pity that someone so inept as me or us are taking this case, because if a very good lawyer was taking it, it is a beautiful case. And I don't think that we can do it justice in our inadequacy, in our lack of knowledge. But we'll do our best. At least it's in the court, and that's more than what we're getting, isn't it? So the judges all agreed that for not well doing, using or practicing the faculty of art, it's a bit bit of a strange language, for disobedience or to contemplate done and committed against any ordinance made by the college, they may commit the offenders without bail or without main prize. That success spurred the college to move it. So they, because it was the doctors' council that had said, made the decision that they were able to commit people to prison for as indefinitely as much long as they liked. And the King's Court bench had agreed with them. So that gave them power, and they went up against Bonham again. Now, by suing him in the King's Bench for £60, equivalent to £13,000 in today's money, and for maintaining, they prosecuted him for maintaining an illicit practice. Now remember, there are two here. One is illicit practice, practicing without a license, and one is injuring a person by behaving badly. Keep that in your mind. In the counterattack, Bonham brought the suit in the common pleas, requesting £100 of damages from them. He used his common law against them and alleging that they had trespassed against his person and wrongfully imprisoned him against the law and the custom of the Kingdom of England, and he claimed £100 from them. So he's taking the power back. We always want to be taking our power back. The case was heard in the Court of Common Pleas by Chief Justice Sir Edwin Coke. And with the decision was finally reached that the college lawyers had argued that the two acts of Parliament and the Royal Charter intends that none shall practice here but those who are most learned and expert and more than ordinary. So you have to have a special skill. As such, the college was free to punish for both practicing without a license and for malpractice, with the 1553 Act giving them the authority to imprison those they judge. Bonham's lawyers replied by arguing that the Acts and Charter were intended to prevent malpractice and not for practicing without a license. So they're saying, because that comes back to the common law of cruel punishments or unusual punishment to a person, that you've hurt someone for no reason, you've damaged them. But the practicing without a license, they couldn't send you to prison for that, because it's the people's choice if they want to attend which practitioner that you want to attend. If you want to go to the massage therapist or you want to go to the aromatherapy person, you can do that if you want to, but they're not allowed to do anything to hurt you. And if they do something to hurt you, which includes not advising you correctly to deal with cancers, then they can go to prison for that, but not for the practicing, because there's many kinds of medicines, Chinese medicine, all of that, right? So they said that the only time that the College of Medicine could send you to court was if you had damaged the person. And Bonham had not damaged the person. Okay, everybody's with me now. Going to get to the good bit soon and how this relates to our case. So, moreover, in Bonham's study, and to become a doctor means to be considered capable of teaching. When a man brings with him the ensign of doctrine, there is no reason that he should be examined again. For then, if thou wilt not allow of him, he shall not be allowed, though he is a learned and grave man, and it is not the intent of the king to make a monopoly of this practice. So they said the king does not intend that the only people that can help sick people are medical doctors. There are many types of illness and many types of people that can assist in that. And the king did not intend a monopoly only for the physicians of the medical practice. So, as such, the act doth not inhibit a doctor to practice, but only punisheth him for ill-using, exercising, and making of physique. In other words, it covered only malpractice and not illicit practice. The malpractice meaning that they cause injury. So they better not cause you an injury, then they'll go to prison. Walmsley sided with the college, with Walmsley delivering the joint opinion. He said that since the statute clearly said no person could practice without the college's license, only one verdict was acceptable. As the college has the valid licensing authority, the Royal Charter was to be interpreted as granting the college on a duty on behalf of the king. So these were the arguments. So the arguments of Bonham is that he can only be prosecuted for not having a license, but he cannot be prosecuted for the injury to the person. Oh, no. He could only be prosecuted if he injured a person, but he could not be prosecuted for practicing without a license. And since he had not injured a person, but only practiced without a license, then they should not have sent him to prison. Okay? But the Walmsley had said that the college had the right to send people to prison for either or, as they had that right of the king. Has everybody got any questions on the arguments here of the two? You can tell me. Open for a bit of discussion. Any questions? No questions. All right. Everybody's comprehending. So those are the arguments. Now it's going to get to the bit where you're going to see where it affects us, because it does kind of come to us, is that here is the thing, is that we give consent by our voting for Parliament to make laws to govern over us. But we do not give consent for them to govern over us in an arbitrary manner that is repugnant to our indubitable right. And when they govern over us repugnantly to the indubitable right, then we're saying that the court, the High Court and the Governor General have the right to step in and override Parliament. That is the argument that we're saying. Yes? So we'll see what happened in the Bonham case. So in the Bonham case, it is the office of a king to survey his subjects, and he is a physician, the king is a physician to cure their maladies and to remove leprosies amongst them, and also to remove all fumes and smells which may offend or be prejudicial to their health. So anytime anything's bothering us, it's up to the king to step in and help us if we ask him to do so, which we have done. And so if a man be not right in his wits, the king is to have the protection and government over him, lest he being infirm, waste or consume his lands or goods, and it is not sufficient for him that his subjects live, but that they should live happily, and he discharges not his office. If his subjects live a life, but only if they live and flourish, and he hath cure as well of their bodies as of their hands, and goods for health for the body is as necessary as virtue for the mind. So he's saying that the king has all power over us to make sure that we are being governed in happiness and flourishing and being treated well by our governments. And as long as our governments are treating us well, the king has no right to intervene. However, if we are not being treated well and we're treating with bad smells and fumes and prejudicial to our good well-being, then the king has the right to step in, and we have so called him. As such, in Walmesley's mind, this is what happened in 1840. The New Zealand people, both including Anglo people that were living and New Zealand Maori that were being treated as slaves and having all their land stolen, and this is why the king came to step in to help them, because that is their duty. And as such, in Walmesley's mind, the king had a duty. Walmesley said the king had a duty to protect the health of his subjects, and the king had delegated that in its entirety to the college. In addition, Bonham had given an absurd and contemptuous answer when he claimed that he would not submit to the college, and it should be a vain law if it did not provide punishment for them that offend against them. So they said Bonham acted in contempt, and if we don't enforce the laws of the college, then their laws are a waste of time because there's no punishment. Everybody will just run roughshod all over their laws. So we have to uphold what the college decided. The king had delegated part of his prerogative powers to the college for the purposes of punishment and imprisonment. And as such, it had the right to sit as a court. That's saying the medical council had that right. Now, Coke is going to come back with his arguments. He's saying that Coke delivered the majority opinion in favour of Bonham. So he ruled against the college and ruled in favour of Bonham, with Daniel and Warburton agreeing. He undertook a closer reading of the college's charter and their associated acts, and he divided the relevant passage into two clauses. One gave the power to fine practitioners without licenses, and the latter specified that they could imprison a practitioner for not well-doing, using or practicing physique. So, if you go to a masseuse, right, and they are acting as a practitioner of medicine, of a certain kind of healing with no license, right? But once they do things like inject you with forbidden substances, cut into your body, things like that, acting as a proper medical practitioner, that's illegal and they'll go to prison. But as for just practicing their type of Chinese medicine or their natural medicine, they're allowed to do that without a license. And so he argued that they had constituted separate powers and issues. The former dealt with authorization to punish the license, which was only a fine, and the other covered a punishment for malpractice, which is going to prison for doing medical practices that you're not licensed for, like cutting someone open. Simply practicing without a license did not constitute malpractice. As such, the college did not have the power to imprison Bonham, who was accused of practicing without a license and not practicing dangerously. Therefore, Coke added something, and this is going to help us. He went further by arguing against the validity of the charter and its associated acts, which gave the college the right to act as both as a judge and as a party to the case, which provided for an absurdity. He said that it's absurd that you can relate this to the Waitangi Tribunal. It is absurd that they act as a judge and then they also act as a party in the case. Now, if you go and look at the judges on that Waitangi tribunal that have given themselves all these lands, those same judges are the ones that are receiving benefits from all of those land settlements. So that is an absurdity, because if you are the judge on a land settlement, that you are going to be entitled to great monies and great lands, then you're going to judge in favor of yourself because you're a party to the case. And I have found many instances of this, but I don't have time for it now. But that is an absurdity. And this is also, I actually can prove that Jacinda Ardern, and I actually can prove that Jacinda Ardern through Nathan Natras, who is a member of the Mormon Church, who is the relative of Vincent Halleck, who is the uncle of Jacinda Ardern, and also must be related to Ian Ardern, who is both of them are area 70s in the Mormon Church, the highest of the highest, who are both related and brother to Ross Ardern, who is running the Pacific, the Tokelau Cook Islands and Niue. The four of them are all related to Jacinda Ardern, and Nathan Natras set up a health care company that does all the health care, and he is the vested interest, and the Parliament of New Zealand have issued all contracts of health in New Zealand to him and his company that he set up in the year 2000. So that is illegal. And so that provides with an absurdity when it's her family that's running, and this is why they want the 50% Maori health care, which is headed up by David Moxon and Lady Moxon of the church, who are all working with the Pacific Islands through the Mormon Church and the tithing and all the healthcare. They're going to make millions upon billions of dollars of our taxpayer money with every one of these organizations that they set up. So they have, that's an absurdity, isn't it? Yes. So then, but that's nothing to do with our case. That's kind of a big thing, but we can ask questions about that to Jacinda Ardern. We can ask a few questions, but we can't accuse, but we can ask questions and make sure that it gets put into the court documents that this is what's going on. Even though it's not part of our case, we'll certainly find a way to infuse it into our case. So to mention it, but he said one cannot be judged and attorney for any of the parties. And it appears in our books that in many cases, the common law, it says here, the common law will control acts of parliament and sometimes adjudge them to be utterly void. So we're going in with our common law and we're getting them to control parliament. And it says that they can be made utterly void. For when an act of parliament is against the common right and reason, or when it is repugnant or impossible to be performed, the common law will control parliament. So that's what we're saying. And adjudge such an act to be void. And therefore, in Thomas Trigger's case, Hurl states some statutes are made against law and right, which those who made them perceiving would not put them in execution. So the people that, what it's saying is that the people that made the law thought to themselves that nobody would be able to go up against them because they were a law made in Parliament, and that the Parliament, nobody could override parliamentary law. This is the issue. can we as people override parliamentary law when it's repugnant to us? That is the question.
According to this, yes.
Even though we voted them in, can we override specific points of law that they make because it's repugnant to our Bill of Rights? And in those cases, it was one. Now, so you know, basically, you can go ahead and read that case at some point if you want to. But then we're going to go back to Justice Palmer here, Jeffrey Palmer, and oh, I see somebody said something. Does anyone want to speak?
That was me. Where did you find this?
Because I went to so I got this one here, Maxine. I went to investigate Justice Palmer to see, I wanted to see about him. I didn't even know that he was Jeffrey Palmer's son.
Yeah.
So I got quite a shock. And then because I know Jeffrey Palmer is the writer of the 1990 Bill of Rights Act. And he's the writer of but it seems that Justice Palmer might have been a bit pressured because as soon as he put out the 1990 Bill of Rights Act, he stepped down. And it seems that he's been writing against it ever since.
Oh,
so
yeah.
I'm not sure quite what went on there. But anyway.
That's interesting. That's interesting in itself.
Yeah.
Because Jeffrey Palmer's son is the High Court judge who we've seen first. That means technically he is automatically biased on our side because his father is against them.
Yeah. Yep. You're right, friend.
You know what? I'm not going to go with that because he let the case through and he ordered them to front up on the 20th. And he said to them, you better work with these people. So,
and he gave you so much room in that thing. He gave you he allowed you to speak for for a long like he allowed you to speak quite a bit.
Because he could see that what they had written was repugnant to what I had written. And but he had said to them, because when they said we are going to move to strike, and he turned around and said, have you seen the letter that I've received this morning and the memorandum? He said, have you seen this? And they said no. And immediately
they tried to blame Kate.
You've got to go back and talk about this again. He looked at me and he said, I can't help you. I can't help them either. But he put in there, you will present your defense on the 20th.
The 20th,
and you will work together with them for their case.
Yeah.
So I'm not going to, and he knows. He knows what this case is about. I have no doubt that he knows.
Oh, of course he does.
Of course
He would
he
have had
does.
to. It would have been discussed in his home forever.
Yeah. Yeah.
He had front row
Since he was
seats.
a child.
Yeah.
And but I've got a big surprise for you. So, what did Jeffrey Palmer say about does the Supreme Court have power to override Parliament in common law when they're acting repugnantly? Right? Let's go and see what they say next because it's going to be very exciting. Does anyone, if you want them to, I'm ironing. All right, keep ironing, yes. Keep ironing. Yes, because I do. Yeah, that's funny. Oh, hang on. Yes, okay, that's funny. So Maxine's ironing. Right.
I'm going to fall asleep soon.
Don't fall asleep. I meant the last bit.
Yeah,
Brent.
half an hour.
I meant the last bit. Look, once you all know, because you're all gonna know, you want to come, you gotta do the, you gotta do all do the work.
Yeah.
If you want to come,
Yeah.
you have to know what we're talking about. And there, I'm not taking dummies in with me. You'll be
unintelligible. Unintelligible.
Unintelligible people in my Oreo team. There'll be none. We'll want clever, smart people. Now, we're almost at the end, Brent. So, he said that if, can you all see that?
Yeah.
Yeah.
There you go. He said that, where did I just put it? All right, so he said that, yes, if Parliament makes a law, and he gave a very extreme example, if they make a law that's repugnant, then it has to be overridden. So the derogative, much from the wisdom and power of the Parliament, that when they said, Parliament is saying, when the three estates, the King, the Lords and the Commons, have spent their labours in making a law, then how can it be that shall three judges on the bench destroy and frustrate all their points?
Yeah.
Because the act agreeth not in their particular sense with common right or reason, whereby Coke advanceth the reason of a particular court above the judgment of all the realm. For it is magnus congruum that acts of Parliament should be corrected by the same pen that drew them, rather than to be dashed in pieces by the opinion of a few judges. So this is going to be the battle that we're going to the court to be saying to them that they've been writing laws that don't make sense. They're writing laws that are repugnant, and we're saying that it is the right of the Supreme Court to take over from them and check all of these laws and remove all of the ones that are repugnant. So we actually are pitting them against each other. That's what we're doing. Right. Notwithstanding, next one, it is generally recognised that the revolution of 1688 marked the end of the doctrine of Dr. Bonham's case. Chief Justice Coke had bravely tried to use the common law to curb the king's growing arrogance, telling King James that the king himself was under God and the law, but public opinion was expressed through Parliament. Now, here is the question. In that particular case, they overrode the king in favour of Bonham. But in our case, we're reversing it. We're saying this time that it's the court's right to override Parliament because they are in the wrong. So, ours is a little bit different. The revolution of 1688 did not assert the supremacy of Parliament. Contrary to popular belief, the Bill of Rights fails to even mention it. There's no mention of the supremacy of Parliament in the 1688 Bill of Rights, none whatsoever. It only says the power is with the people. It is to the decisions of the courts that we must turn in order to discover the legislative limits of Parliament. Now, show you exactly what that means so that you know exactly what we're talking about. We'll go to our beautiful 1688 Bill of Rights that we all love, which is the common law. Go to there, and then we'll see our 1688 Bill of Rights. Don't go to sleep, Brent, wake up.
I'm listening.
Right, now we'll go. Can you see the 1688 there or not? Hang on.
Not anymore.
All right, so if you go to here, what you'll see that I've often expressed this, but I'll show it to you again. It does show you there. What it says is, it lists all of your rights, and it says here, down here, it says how they must govern us in unity, peace, tranquility, and safety, and many, many other things in there. And then it says that, I'm in a very important video, it's 10 more minutes. Then it says that in the supremacy, that, oh no, not the supremacy. Here it says that the means, if they don't govern us according to all of these rights. Now, Brent was having a problem with his guns, and they were trying to take away his guns from him. And here it says here, the subjects' arms, that the subjects which are Protestants may have arms for their defense, suitable for their conditions, and as allowed by the law, which means that they can't make a law stopping you from having guns if you're a Protestant. But what they have to do is to make laws that allow you to have them, but that allow you to have safety as well. And so anyone that has got guns, having your guns taken away from you, then you can go to, and it tells you here that
Forfeiture of person.
the only way to, yeah, that's also forfeiture of person as well. The SNAs, SNAs come under forfeiture of person without conviction. That's the SNAs. Taking all your guns, that comes under your right to have guns. And another one that you're entitled to in regards to the United Nations and the WHO, I do declare that no foreign prince, person, prelate, state or potentate ought to have any jurisdiction, power or authority within our realm, so help me God. These are all the rights that you have, many, 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 many. And then it says there, under the frequent parliaments, that we demand that they will not make any judgments or any proceedings against any of these rights. They're not allowed to. Right. And then it says, if we have a problem with that, our means for obtaining full redress is a remedy that we must petition to the king. But we do that through the Governor General. And then it doesn't say that Parliament has any supremacy whatsoever.
That's right.
Then it says the supremacy lay with us.
Yeah.
We have it. And then the way that we do it is that we go to the court and we ask the judge. Now, this is saying that we take our supremacy, we give it to the judge, and we ask him for a declaration to say that all of the ministers must stand down on this issue. And we will get our declaration, which is what we're asking for. So this is the way that you are supposed to do it. So all the common law people are correct. I'm not saying that they're not correct. They're all correct in what they're doing, but they have
through the wrong way.
Doing it in the right way.
That's
so
right.
I'm saying, yes, keep doing what you're doing, but there's a process that you have to do it. And you do it by making a prayer for a declaration. Now, better hurry up because Brent's going to sleep. So, so Justice Palmer, so I got this when I was researching Justice Palmer, and it came up under the thing that he was, it came up under his, go and look at his cases and this will come up. So that the supremacy of Parliament, it says there, contrary to popular belief, the Bill of Rights does not even mention that Parliament has any supremacy whatsoever, and it doesn't.
No,
It
it
is
isn't.
the decisions of the courts that we must turn in order to discover what are the legislative limits of the parliament.
Parliament. Yep.
The court will decide. Now, this is pitting them against each other. And it was once said that if an act of parliament were to create a man judge in his own case, the courts will disregard it. That dictum, however, stands as a warning rather than an authority to be followed. This is for them. See, we're putting them back in their law.
Yeah.
Never mind what they keep saying, what we're all doing wrong. They need to look at what they're doing wrong. We, which is them, sit here as servants of the Queen and the legislative. We to act as regents over what is done by Parliament with the consent of the Queen, Lords and Commons. I deny that any such authority exists. If an act of Parliament has been obtained improperly, it is for the legislature to correct it by repealing it. But so long as it exists as law, the courts are bound to obey it. This is what I've been saying to all you people.
Yeah,
if that law exists, you have got to obey it, but you are permitted to go to the court and the court can overturn Parliament.
Yep.
That's what they say. But the studies of Bonham's case have suggested differing explanations of Chief Justice Coates' famous statement. It was a famous statement that the common law could overturn an act of Parliament. It would seem that the Chief Justice used the tools of his trade, precedents, but with the knowledge that he was breaking new ground in the assertion of this power. His own words summed up his approach when he wrote, "Let us now peruse our ancient authors, for out of the old fields must come the new corn." The new corn. So this is what we're doing. We're going back to our ancient laws from the old fields to create the new corn. Now, Justice Coke lost his job and was ordered to change everything that he wrote, and he refused it and he lost his job. And we're coming back 400 years later to fight his case for him. Can you imagine?
Wow.
400 years later, we're coming back
and fighting the same case.
The same case as Justice Coke. It's biblical.
Yeah.
All right.
What we're doing. You can't even believe what we're doing 400 years.
Years later.
His spirit is here. We're going to have to get a picture and we'll put his picture up, and his spirit is here. And we are fighting for him 400 years later. Can you even believe it?
That's amazing.
How long have you been sitting on this?
Hey?
You must have been excited when you found this, Kate, or when you read through it.
I'm very. I didn't realize what our case was about. I'm just. It's evolving. I told you, I'm not doing this. The spirits are doing it. This is not me.
Yeah.
I don't even know what's going on.
Yeah. They're coming through you.
They just send me stuff. They say,
yes, and this is what I'm saying. When we go and front up on Wednesday, it you know, we're feeling our way here, and it's like I have no question that we're going to be looked after. We're going to be looked after right through whatever happens.
Of course you are. Of course we are. We've all believed that. Yeah.
We will. And I do believe we will, and I do believe that the right people are going to be in the right place. I believe that this case has sat there for 400 years, and it's time that it was brought back to the front and we vindicate Justice Coke. So, but, however, there's even more exciting things to tell you to come. It's more exciting. Right. So, are you all excited as I am? Well, I'm very excited. Now, Lord Cook, C-O-O-K-E, who was the one, Cook J, was the one that did the Declaration of Inconsistency, I think, for Arthur Taylor. That's another case. But it's funny how we have a Cook and a Coke. By 1979, Dr. Bonham's case, see, they've been arguing about this for decades upon decades upon decades, might reasonably have been regarded as some sort of skeleton in the constitutional closet. However, in what was described as a quiet revolution, which has been occurring on the benches of the Court of Appeal, Cook J, as he was then, while never directly referring to Dr. Bonham's case, began publicly questioning the supremacy of Parliament. Yes, in a dissenting judgment on the issue of whether the Accident Compensation Corporation enjoyed exclusive jurisdiction to determine whether a person had suffered injury or loss by accident. He said it would be a strong and strange step for Parliament to attempt to confer on a body other than the courts power to determine conclusively whether or not actions in the courts are barred. So they tried to give ACC power over the court in regards to ACC compensation. And he turned around and said, you can't give them that power over the court, you don't have the right.
Yeah.
But he used the Bonham's case, so he once again asserted the supremacy of the courts. Indeed, we have reservations as to the extent in which New Zealand, even an act of Parliament, can take away the rights of citizens to resort to ordinary courts of law for the determination of their rights. So I think our case will go to the High Court because they won't send it to the ordinary court. That's going to be an issue of which court we're going to go to. If we go to the ordinary court, it's not going to be good. If we go to the High Court, this is going to be one hell of a case. It is going to be huge. So
it'll be massive.
It is going to be massive. This is
it'll take them a while to give an answer. It will be massive.
But why would it take them so long to get an answer though? Because it's pretty straightforward under the 1688.
But there's so many technical things. I mean, our law is based on half of like a massive amount of this stuff. So it'll be a massive discussion. They're going to have to really look at it, I assume.
Well, that's
it's not going to be a plain decision.
What she's asking for is a declaration on which law is the highest. And yes, it will turn over everything, and they have to do it.
Yeah.
It's all there.
I mean, it will be real. It will be interesting how it plays out. It'll be massively interesting, and we've been a part of that.
Yes, yes, we have. Turn your mic on, Kate.
We all have. It all started with Chief Nene.
Yeah.
And the chiefs, you can't even believe. Getting to the step where we are now, some of you don't know, but if you knew, this all started with the chiefs in 1835. So this has been going on in New Zealand for several hundred years as well.
Yeah.
And so it is this is like a turning point in New Zealand. It could go against us, where they realise that the Majesty's got too much power and try and throw her out.
Yeah.
We don't know how this is going to go. We really don't. This is going to be just so huge for the whole of New Zealand for all of us. I think
Yeah.
everyone's going to be watching this
Yeah.
case. We're going to be famous. Get
Yeah.
ready for fame. We're going to be famous, and it's going to be great. Right, now let's,
Yes.
but wait till you get to the end. I didn't get to the surprise yet. Now, so he said that this perhaps is perhaps a reminder that it's arguable that the common law right may go so deep that even Parliament cannot be accepted by the courts to have destroyed them. They
Yep.
can't do it. And all of these things that they've been doing, every single one of them have been against your common law right.
Oh, hell
Yeah.
yeah.
The last bit was written, the Bill of Rights 1688, which established the Parliament's power over the King, did not provide for Parliament to then relinquish it again to the King or Queen. Now listen to this carefully. Through his or her ministers. So they're asking the question that they gave Parliament the right to make laws in place of the King, over the King.
Over the King.
But they didn't provide, they reckon, this is what they reckon, they did not provide for Parliament to then relinquish that power back to the King through their ministers. So Lord Cook's dicta provided support for the implementation of the New Zealand Bill of Rights Act in 1990, and perhaps that was their function. That to suggest that Lord Cook would have withdrawn judicial enforcement of legislation lightly.
Yep.
It is reserved for the unexpected case, the grossly unjust law. So I have to read that a little bit more, but I think that what they're saying was that the 1990 he provided for support for the implementation of New Zealand Bill of Rights, but it should only be used, I think, it's only supposed to be used for very gross, unjust laws. I'm not quite sure what that means there, whether it's in favour of the 1990 or whether it's in favour of the 1688, but we'll go back and study it to see if we can decide that. But now he's talking about the New Zealand now has the New Zealand Bill of Rights 1990, which guarantees a range of human rights, but this is important. It does not have superior law status and thus maintains the supremacy of Parliament. Well, this has been the battle because through the 1990 Bill of Rights, Parliament is supreme, but through the 1688 Bill of Rights, the courts are supreme.
Supreme, yep.
So that is the battle that we're taking to the court, because we have said to the court, in the event that you have two complainants, one on the 1990 and one on the 1688, which law is supreme?
Yeah.
And the question's already been answered by Justice Young, because he already said that the supremacy of the courts to take over the laws of Parliament, if necessary, sits with the court. And he said that includes the 1990 S4, S3 and S4. That's to do with the executive power. So he has said that. And So that's going to set up a battle because Parliament had thought they were sneaky with the United Nations and the human rights. They had supreme law with no interference with the king, no interference with the Governor General. They could basically do what they wanted.
Yeah.
And you have had no power. And
They
we're
have been
shoving
doing
it
what
into
they want.
court. And we're saying, hey,
Yeah.
that still goes under us, the people.
Because
And
1990 doesn't have superior law status.
Exactly. That's exactly right, Sharon. You're right there with me. That's right. So, although in a review of its first decade of operation, one commentator suggested that the courts actually treat it as an entrenched superior Bill of Rights. They're trying to make the Bill of Rights a superior. I think I'm going to send this video to the court. I think they're trying to make the 1990 Bill of Rights as an entrenched Bill of Rights. Whether or not this is so, at the least it has had the effect of providing a set of navigation lights for the whole process of government to observe. Although Bora merely affirms the rights listed within it, the courts have used it as the basis for legal remedies in the event of breach, notwithstanding the removal of a remedy clause at the select committee stage of the bill's passage. Oh, so when they were putting the 1990 Bill of Rights through, there was a removal of a remedies clause at the select committee stage. Now this is very important to us because the new declaration of inconsistency set up by Chris Barfoy for the Declaration of Inconsistency, they've said that they are entitled to a remedy, which is the Declaration of Inconsistency, and they use the United Nations conventions, but it says it right here.
They've shot themselves in the foot again, Kate.
They freaking did, Sharon.
Yes.
I've just only seen it. It says it right there. When the 1990 went to the select committee, there was a removal of the remedies clause at the select committee stage.
So their inconsistencies are out. They're out. The inconsistencies are out.
Before it was passed.
Yeah.
You know, I hope I can do this justice in the court because I don't think I can.
Oh, you can.
You can.
You can.
You can.
I think I'm just going to send this video to the court and say, there, watch this video. This is what I want to say.
No, you won't.
I think I will.
You can. We got this.
So you will go with
You've
that.
got it.
You have.
We've all got it. We've all got this.
No, that Declaration of Inconsistency is illegal for a start because the select committee already made the decision about the remedy, and that they said they would not be able to have the remedy clause.
Yeah.
And they used the United Nations Covenant of Rights that Section 3 says that you would be entitled to a remedy. And they said due to that they would be allowed to have the Declaration of Inconsistency, of which Chris Barfoy is trying to pass the bill. And I will be talking to Chris Barfoy about this.
When was this written? Because given all the proposed bills that have been running through everywhere, they may have covered their ass, possibly.
Why do you got to be a Debbie Downer all the time?
Because I always like to check my bases. I don't like getting excited until you cover your ass. They'll be covering theirs. Well, hopefully he's not. I mean, he was a journalist, so hopefully he's fucking fucked up big time. And then that would be a brilliant for our case. It's like you don't even know what laws you're
hell
making.
yes.
Can you send the whole video to the court with that bit in it?
I think we're going to look at it, and I think we might just send this video to the court and say, there, look at that. That you're allowed to send video evidence.
Yeah.
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 Cut out my swearing then.
Well, you know.
Oh, hell no, we're leaving it there.
Then let them learn a few words from us.
Fuck yeah.
We've had to learn all their words. They can learn some words from us, from the commoners.
The proper ones, yeah.
Yeah. They're a bunch of cockwombles.
Oh, well, that has to be a z.
There's got to be a beep beep.
Yeah.
Pay attention before he says something that's bad again. Right, are you ready?
Yes,
So
go.
this is amazing that we've found it.
Yes,
So
go.
said, more recently, they said that they were not withstanding. So they did not agree with the removal of the remedies clause. And so they must have done that. That's terrible. That's only come about in 2019.
Yep.
Although these hang on. More recently, the Court of Appeal has stated that they have the power and sometimes the duty to indicate that a statutory provision is inconsistent with the rights affirmed in Bora. This is a new role the court has created for itself, in contrast to the latter Human Rights Act of 1999 UK, which explicitly sets out this role of judicial comment on the substance of legislation. This is just such a huge case. Now, here's something going to be, am I getting to the fun bit yet?
We've already gone to the fun bit.
No, I've got a more fun bit. I've got a fun bit. When you see what Jeffrey Palmer said, you're going to be very surprised. What he said, I haven't read all of this, but I skipped to the end. And this is what happened. Listen to what he said. If a judicial challenge to an act of parliament occurred in the future, it might not be seen as a revolution, but as a natural development of both New Zealand's constitutional arrangements and of the common law. He's saying, in the meantime, he says, a definitive answer might be comforting, but he says, but for now, there is not, and arguably should not be one. They're debating. They said the debate is more important than the answer. So they have been debating. He's saying that since this activity has never occurred, he's saying that, and he's more or less saying it's not likely to occur in the near future. He's saying we'll just keep debating.
Well, he was wrong.
And we've just come and thrown them a six ball, and we've said, no, you won't be debating on it anymore, mate. We want answers.
We right.
Answers, and we're done with your debating because we're all in hell.
Yep.
With your debating about it.
Of wages.
So what it's just, so that is what our case is about. The 1688 versus the 1990. And the core of our case is that we have asked, and that is in the statement of claim, that we have asked which law is supreme. the 1688 or the 1990.
We know which
the
one.
Subordinate law
We know.
or the 1688. There's only one answer.
There is.
Of course
Only
there
one
is.
answer.
There is only one answer because
Well, they
And then
keep
the-
shooting themselves in the foot, Kate, and
They're-
now they
they're
don't
shooting-
want a leg to stand on.
I don't think they have.
They
I think I don't know what they're going to do, but I'm sure they'll come up with something sneaky. Anything
Yeah.
they can do to get around the communists, they're going to do it. Trust me.
They
But-
will.
But the argument is not with us.
No,
The
Yeah, it's gonna be
argument
with
is
them.
with them.
with them. Yeah.
The
Because-
parliament in the courts.
And this is the essence of all our problems. The argument has
Yeah.
always been with them because they went and made a whole bunch of laws and they didn't sort it out, as you can see there by Jeffrey
Yeah.
Palmer. They didn't sort it out before they put it on the public. They said, let's just throw all those laws out there and see what happens. And it's a disaster is what has happened. It is. They are
Yeah.
incompetent,
And
aren't they?
competent.
Yes,
Yep.
very
Yeah.
incompetent.
The laws, yeah, they just threw them out onto the public and they said, deal with that and we'll see what happens. And it's been a disaster and our country has been destroyed because of it. And I will say that. Our country has been absolutely devastated by
Yep.
this little game that they thought that they will play.
It's interesting that it's our generation that have taken this to court. Like, you know, the amount of lawyers and
Yeah.
everyone that's walking out of those educational institutions,
Yeah.
and none of them have even sniffed at this. Either that or
Yeah,
they're
exactly.
purposely trying to bury it, and it's
Yeah.
our generation. And I
That's now
hope when it
taking-
comes up again
and
for
it- yeah.
the future generations, I hope they
Like
too
I
will have
hope
the
not.
nous to do this. When
Kate, you
because
need
it
to
will.
reincarnate yourself and
Call
keep
out.
going for the next one.
I do believe
No.
we are the reincarnations already and we will for
Yeah.
sure.
Yeah, we are
We
reincarnated.
reincarnated. It all comes from Jesus. Jesus
Yeah.
made
Yeah.
these laws because the 16 people on the cross and Jesus was put on
Yeah.
the cross and it was exactly because of this, because they had two courts of law. They had the court of the hewn stone and the court of the unhewn stone. And they took Jesus to the court of the unhewn stone and he was put
Yeah.
up on the cross and put to death. And then they realized at the time of Jesus that they must not allow this to happen again. It was so horrendous a time. And
Yeah.
Jesus came back in 1688 and he left us with a will.
Yeah.
And he said, I will not leave you in the naked in the jungle with all these laws. And he said, I know that you are as children and you're naked in the jungle with all these laws. And he said, I'm going to give you these protections, not the ones that govern, not the king, not the you, these protections. And Jesus has arisen again and we are ascending to the heavenly realm. And Jesus has arisen again to lift us up. We're going to get put up to the highest place where we should always have been.
In the first place, yeah.
Under, but we're going to lift ourselves back up to the heavenly realm and everything will set right then, everything. Because they should not have done this to us.
Yeah.
They should not. It's very bad.
There you go.
Are you going to speak about the two buildings in Wellington, the hewn stone and the unhewn stone?
All right, shall I just spend a few minutes about the hewn stone and the unhewn stone? Okay, so the hewn stone, or let me get them right if I've got the right, is it hewn and which one is hewn?
Hewn has been touched by the iron.
Right, yeah, the
Iron.
hewn stone is the stone that has been touched by iron, and the unhewn stone is the stone that has not been touched by iron. And the Sanhedrin, the temple courts used to be in the back of the courthouse. and they had to be built. The temples of the Ptolemaic law and the Islamic law and the Catholic law, those laws, they had to be built of unhewn stone, because in the thing it says it's thought that it had never been touched by the weapon of war. But you have to think differently. Another weapon that we have, our weapons don't need to be guns, and our weapons don't need to be swords. Our weapons can be the law.
Yeah.
The law.
Yes. And so they had created courts that were made of the hewn stone, and you were permitted to go to the courts of the hewn stone, and you were permitted to defend your case. And courts of the hewn stone had to be conducted in the light of day, and the public were allowed to enter to see that everything was on the up and above. Well, they took Jesus, and the court of the hewn stone had an entrance, one entrance to the east and one entrance to the west. And the exit, something to do with the east and the west. And if you look in the Queen's Jubilee song, it does say about the east and the west, and it's talking about the court of the hewn stone. Now, when they wanted to get Jesus, he was killed because of his speech, because he spoke against all of the laws. They had created hundreds and hundreds of laws, just as Jacinda Ardern has created hundreds of laws. And then they took Jesus to the court of the temple, which was of the unhewn stone. And it was done in that darkness, and they slapped him and they beat him up and did evil, horrible things. And they convicted him in there, and nobody was able to see the court case or how they decided. And then, of course, the next day he was put on the cross and taken with 16 other people and nailed up to the cross. A very horrible thing. Well, Jesus died and ascended. Well, fast forward to New Zealand, okay? The St. Pauli ship, which I come from, the St. Pauli ship, the only ship that came out from Germany, and the St. Pauli ship, the people that were on the St. Pauli ship, they were involved in the excavation of the marble, the Canaan Marble Mountain. Okay, and the Sextus family from the St. Pauli were the first ones to ascend on the Victoriae number 2, to ascend to the court and put themselves under the subject status of the Majesty for protections. The second person to ascend in 1847 was Tamati Wakanene, and he ascended to the court and made himself a subject of the Queen for the protections of the Queen. And then following that, in 1858, another German group ascended to the court, which included my another great-great-grandfather. And then in 1865, the New Zealand Maori, together with the Anglo people, all of us ascended to the heavenly realm and made us self-subjects under the protection. Now, the Canaan Mountains that were excavated in Nelson built the Parliament building and also built the Supreme Court of New Zealand of the hewn stone. Yes, the hewn stone. Yeah, it's very interesting. And it gets even more interesting than that. In around about the year 2004, they made the application to have the 1688 Bill of Rights removed, and they built a new courthouse directly behind the court, the Supreme Court of the hewn stone, and they built a building of unhewn stone directly behind it, exactly as in the time of Jesus. I am telling you, they're trying to kill Jesus, the 1688
again.
Jesus, and they're trying to kill him again. So they built that court. And if you remember what I just said, that the Sextus family from the St. Pauli that came from Germany, they were the first ones to ascend to get their subject protections, right?
Yeah. Yeah.
First case tried in the court of the unhewn stone in New Zealand was, what was his name? Somebody Zowie.
Oh yeah, Zowie.
What was his name? Maxine? She's my
Oh.
note keeper.
Hang on.
See who finds first. I'm gonna find it.
That is a good name.
The first one was, it's down at the bottom, I know, right, I've got it. The first case was,
I've saved it somewhere.
oh no, I had to get this. The first case here, Zowie. Okay, the first case, here's something interesting. The first case held in the court of the unhewn stone was
sorry, but it's hewn. Hewn's been done with the iron, unhewn's without the iron.
Yeah.
All right. Oh, now I'm going to have that all mixed up.
But it doesn't matter.
Yes. Hewn has been, okay, strike everything.
Hewn's bad.
Hewn is the one that's been struck.
Yeah.
And the unhewn has been the one
It's
that
pure.
has not been struck. It's pure.
Yeah.
But if you remember that the hewn stone, the tablets of God that came down with the 10 commandments were carved, and that was called hewn stone. And the tablets were smashed and they were recarved again. And it was the Ptolemad that did not recognize the stone of the hewn stone, did not recognize it. All right. So they used to use the tablets of stone to carve the laws into stone so that everybody would know what the common laws were, because people were getting killed. All right. Yes. Now, so the court, so the good one, the proper court is the hewn stone. Is that right, Maxine?
Yep.
Unhewn.
Unhewn.
Untouched. Yeah. Touched and untouched.
Yeah.
Untouched.
Yeah.
Unhewn.
Which one is the good ones? Unhewn or hewn?
Unhewn.
Oh, dearie me.
So it's that little white building in front of that horrendous monstrosity of a
Little white building.
So
temple of doom.
it's called the hall. It's called the Hall of the Hewn Stones. Yeah, ours is the hewn stone. And theirs is the unhewn stone. Ours is the hewn stone, and theirs is the unhewn stone.
Unhewn stone.
Right? So ours is the hewn. Now the first person, I'll show you that court. So the first person, so you can see the two courts here. Do you see that? This is the court of the hewn stone, and this is the court of the unhewn stone here. And it's all made of wood. This is all made of wood, which means that it can be easily, it can be easily penetrated. It can be easily knocked down. It can be easily they can basically do what they like. But whereas the court of, so this one at the back here comes under the 1990 Bill of Wrongs, and this one here that was built from the Canaan Marble Mountains of New Zealand, sacred stone, is our is the hewn stone. All right, and
So that's the good one, is it?
This is the good one here, because it comes
Right
under
one.
the 1688 Bill of Rights, which
White
is
one.
our supreme common law. And the first person, nobody wanted the second courthouse built, but they demanded that it be built, and it's really for the United Nations, it's not for us. And the first person that went to that court was, hang on.
Muhammad,
So
wasn't it? Muhammad.
is this guy here. The first person that went to that court, stop it.
Sowie.
The first person that was a man called Ahmad Sowie. Now, if you remember that my family was number 2 that ascended to the heavenly court and got the subject status, and Chief Nene he went on number 11. He went in 1847. We were number 2, but look here, Sowie was number 2 in their court.
As well.
Because number 1 establishes the court, and number 2 is the first case. And number 2, the first one was this man called Sowie. And I'll tell you a little bit about him. He managed to, I won't tell you exactly about him just yet. How did he win his case? He wanted to be a citizen of New Zealand. He won his case through the New Zealand Bill of Rights, which was connected to the International Covenant on Civil Rights, which was connected to the Refugee Conventions. And under the Refugee Conventions, he fought his case based on that, all right? And in the end, he won his case. He said that if he was sent back to his country, that he would be killed. And so therefore, under the Refugee Covenant, he was not allowed to be sent back because of that reason. But however, in 2005, his government had removed that death penalty and given an amnesty to everyone, and he could have been sent back. But instead, they let him stay in New Zealand. And then eventually they said that he could stay in New Zealand because he'd already been here a long time, so therefore they would give him citizenship. Okay. Now, as soon as he got his citizenship in 2014, I don't know if it says it here, but as soon as he got his citizenship, he went immediately back to his country of is it Eritrea or wherever it is. So he went back to his country. Please don't interfere. So I'm only going to say a little bit about him. Algeria. He was from Algeria, and I'll just say a little bit about him in that he won his case through the Refugee Appeals Authority. He was refused. He had been convicted. Let's see. He was working for a thing called the Islamic Salvation Front, and there was something to do with elections. We don't need to worry too much about that, but he was tried and convicted and for plotting against the state and some other assassinations and stuff like that. He had received life imprisonment, and altogether he had received 6 life sentences and 2 death sentences against him in the Algerian trials. He managed to escape and he went to Belgium, where he committed more crimes, and he got convicted and a suspended sentence in Belgium. But then he decided to abscond, and then he went to Switzerland. Switzerland paid him. Switzerland actually paid him 1,500 francs to not enter their country and go and live in another country, which he did. He was also convicted in Belgium, and he was convicted also in France, I think.
Oh my goodness.
Then he went to Malaysia, and then he got a fake passport and went to New Zealand via Vietnam. and got imprisoned in New Zealand. And everybody fought against this case, including Helen Clark, but eventually everybody just dropped it because he wrote a New Zealand poem. And since he wrote a poem in New Zealand, yeah, it's true, about migrant birds, they said that he was the most important New Zealand poem writer of all time. Best New Zealand poems he got.
What do you
And so everybody dropped the charges against him because he was a poem writer. And so he is eligible to be in New Zealand Parliament in 2023 if he chooses to run for elections. He's permitted to be. Now he won his case. So let's go back to the court of the hewn, never mind him, don't worry about him. The court of the hewn stones is biblical, that our court is made of the hewn stones, specifically from the Marble Mountains. Let's have a look. So we'll just go there to the Canaan. These are called Canaan Marble Mountains. Now, when you want to hear about God can move mountains, he really can. He really can. He will move mountains for you. And he did. He literally got the people in Nelson to get these hewn stones and build that for you, so that your people and your descendants and descendants and descendants would all be forever protected from the tyranny of governance and slavery. Yes, and God really does move mountains. And he moved, and these are the mines here. The Canaan, I'm not sure if these are they're called the Canaan Marble Mountains. Oh, we have to be careful because there's just Marble Mountain, and then there's Canaan Marble Mountain. This is the Marble Mountain on Takakaka Hill. Yeah, and these are our family members. Can you see them? Moving the mountains. There they are. These blocks here are the blocks that were used to build the courthouse and the parliament. And so they're very, very special. And there's a picture here with a lovely Maori guy working. Some of them are different. You have to be careful because this one here, see, this one here is in Turkey.
Yeah.
So this one is in Turkey, but ours are called the Canaan Mountains, and very lucky that we actually, in God's world, we have to go back to the Canaan. Make sure we've got the Canaan. So our now this is a place in the biblical times, I think, called the Canaan land. And
that's where the Canaanites and all that come from.
Yeah.
Yep.
It goes back to Jesus and everything. The 1688 Bill of Rights is the will of Jesus. And Jesus moved mountains for us. And this is just all the people being killed and being tortured and being put in slavery. And when Jesus came along and they took him to the court of the of the unhewn stone, and he had no power for speaking. They took him for speaking and he had no power, and they killed him for it. And so they sent the people on the St. Pauli ship to New Zealand to build the court from the Canaan Mountains that are right there in New Zealand, right there in New Zealand. Can you even believe that? That's how special. That's how special and perfect that you all are to God. That's how special God not every country have these marble mountains. And New Zealand, and Jen says Thailand does, and New Zealand had it. And so it was called, and your court that you go to with your 1688 that we're fighting for is made of the Canaan marble mountain, that God moved the mountains for you. So you would have power. Isn't that special? How great they are?
Yuri.
When Kate and I, when we talk about the spiritual side of things and stuff, I think everyone gets so caught up at the moment in this Māori Pākehā debate about New Zealand.
Yeah.
And when Kate went through the case about Zoe, I hope people realise that this is bigger. Like you're talking, when you look at the surname, and he's not the only one. He is not the only one that are coming in. So it's this whole spiritual side. Like Kate and I have had discussions, and then we'll be reading through something, and then just hit on something massive spiritually. And so when Kate talks about Jesus and stuff like that, because we can't win this by ourselves. No man can fight this. Like this is huge. And it's scary. It's scary for what we're facing at the moment. But it's bigger than the whole Māori, Pākehā, New Zealand thing. It's massive.
Yeah.
Yeah, that's what we're fighting. It's not some little thing we're going to court and getting our little rights back so we can go back to our little lives and everything's going to be. It's huge what we're fighting.
Huge.
Mm.
Yeah.
Because Brent wants to. Brent, you talk. What do you think, Brent?
No, I just went, yeah. I'm just agreeing.
All right. Well, you agree then. All right. Well, you can't be dressed like that in court. I was going to send this to the court, and I can't with your nipples.
We're not in court yet.
Can I?
Oh,
We're not in
nipple
court.
showing. I don't want to see
My
your
nipple
nipple.
is not showing. It's a tattoo.
It's a nipple. It looks like a nipple
It
for
isn't.
lying.
My
I
nipple's
want to see
down
your
there.
nipples.
no, you'll definitely have to come
Tattoo.
You can definitely delete that last bit of that.
I know. I don't know how to cut it. But
As long as you got no iron through those, you'll be right. Otherwise, it'll be a Hewen nipple. on Hewen nipple. The significance of the Hewen is specifically, biblically, the iron that was used. The iron back then represented nation conquering and weapons and conquering of nations. That's what Hewen, non-Hewen, and Hewen stone means. So when we do talk about this whole spiritual war, I don't believe me or believe us or not, but this is huge. This is it's sort of lining up to look like Armageddon actually.
it is. But even when you don't always have to think of weapons as being metal, guns and swords. They realize that law could be a weapon that can be used responsibly to punish people responsibly, that you didn't have to kill people and torture them, that you could have responsible punishments. But they also realize that the people that are in power also need to be held accountable. Look, Sharon's got the cross shining in her room. Look, there's the cross. Look. Oh,
yeah, I can. Sharon. I can see it. It's up there.
You see the light shining in Sharon. Yes. Yes.
I told you I've always had him with me.
Well, he's right in your room right now. And Tamati, so it can also be a protection and a weapon for us, because back in Jesus' time, the leaders were horrendous to the people. And God said, hey, my people should have a law to protect them, to protect people against the powers that be. And so that was when they realized that law could be a weapon to help and a protector to help everyone. And that's why they made the court like that. And do you know that Tamati Wakanene, he ascended in 1847, and on the 26th of September. So his number was 26, and we're going to look at all the numbers on the periodic table. And the number of 26 on the periodic table was iron. So here's iron on the periodic table. And we were number 44, and I think we were gold on the periodic table. Hang on. Just have a look here.
Wow.
If you go and look on the periodic table, all the numbers come up. We'll have to do a video because I know that Jodie loves the numbers, but all the numbers come up. Oh, hang on.
Do. And do you know what's really, I don't know if I should say this while you're recording, but my father's initials was AGU, which is silver and gold.
Oh, yeah.
Well, yeah, we're seeing a lot of these things.
Yeah.
So on our periodic table, number 44 was ruthenium. Where was the AU? AU was
79.
gold. Yeah, AU was gold. 26 was iron. That's right. And we came up under the ruthenium. We're going to do Jodie, we're going to do.
What's silver? Kate, what's silver? What number is silver?
Silver is 47. And Tamati Wakanene ascended in the year 47, which he got silver, and also on the number 26, which he got iron. And so we came on the St. Pauli, which is AU, which is the gold. And now you've just told me that you've got the silver and gold, that you're descended from King Uther. See, we're discovering many of these things. We'll do a video on this whole thing, on this periodic table and all the numbers, that we can trace the numbers back, but we won't do it today because I don't think we can. But anyway, that's going to be the end of our video today. There's so much wonderful information that we've got there.
Yeah.
Yep.
Thanks for
Certainly
that.
is.
That is amazing.
Yep.
I'll go and read that, Case.
Ta-da!
Okay, I'm going to stop the recording. Right, everybody smile for the camera so you get a good look when you're closing. Smile.
Oh, all gone dark.